The trend that we've seen is that the target for audits and compliance reviews has very much been in the business to customer markets, where there is a higher volume of personal data. So that's not to say that smaller companies and the B2Bs and the HCM-only companies wouldn't get audited and reviewed, but we quite often find that the initial focus is around the larger utility retailers, telecoms, that do contain a huge amount of personal information. I'd also suggest that it's important to not be afraid of audit. Actually bring the auditors in and get the feedback from them on what is your largest privacy compliance challenge. It may not be a technical one, it may be a business process one or a paper management process. If you then invest a huge amount in a technical solution, but actually that's not where your largest risk and concern is, obviously you not wasted money, but maybe invested in the wrong order for your compliance. So actually engage with the auditors, go to them and say, can we do data privacy impact assessments? Get their feedback and knowledge. And the large auditors all provide these services to be able to help inform your business on the challenges that they're going to face. And do that before it's the official auditors being promoted by the government, central body, etc., that's actually enforcing those privacy laws. The other recommendation is very much around the priority of the business. I've dealt with quite a few privacy officers that have faced a high challenge from their business compatriots, shall we say, where the business team is very nervous about removing anything. The privacy compliance officer is saying we have to remove everything, and we quite often find that we have to find the middle ground between those two. It's absolutely about a compromise. We have a lot of conversations around salary data. There is a huge concern with payroll teams of not having the real salary information to be able to actually test the payroll. And in most instances, the clients also want to make sure their payroll is running, because if they can't pay their people, they're going to lose their people, and then they're going to lose their business. So it is a pivotal process that is highly important. And people are very, very concerned to be able to say, but what if it gets leaked? Or what if somebody internally in a test system can go and identify what the salary of the CEO is compared to what their salary is? Now, there is some risk around that, and it's an internal risk to the business. There isn't actually a privacy compliance risk in that. The salary by itself is not personally identifiable to the individual. You would need a number of other informations about the name, the address, telephone numbers, to be able to actually connect that to a person without a human knowledge in between of knowing that that employee number happens to be the CEO. So in those cases, it does have to become an internal decision that the business is going to make on their compliance statement. But the privacy laws don't actually dictate what is personally identifiable information. And there is sort of a rule of thumb that's been adapted to that if there's 3 points of personal data that you can identify back to an individual, that is potentially a breach if that information was to leak. But for example, in the utilities industry, the address is so closely linked to the metering that's associated, and therefore to all of the other parties that they interact with regularly, that if you were to scramble the addresses, you would actually present a real issue in industry testing. Or in production, the address is static and it will have multiple people that live at that address. So if we were to redact and delete that address, it's no longer there for the next person that's just moved in. So there can be industry and business reasons why certain personal data is not able to be processed. And that's not something to be afraid of. It needs to be something that you work into your compliance statement, that you document it, you recognize it and you audit it and say, we are aware this is personal data, but this is the reason why we're not removing it. And make sure that that is written into your privacy compliance documentation. And that will then allow you to meet the compliance laws without actually needing to remove the data. So don't always just default to delete. Actually do that review and say, is there a justification, legal or otherwise, that we can use as a compliance statement rather than coming up with a very complex technical solution to what could be a simple business answer.